Good evening and welcome to the Planning Commission meeting of the City of Glendale for December 2nd. Before we have a roll call, I have to extend our sympathies and as well as our heartfelt condolences to the victims of this heinous crime in San Bernardino today, and I think I'm speaking for everyone on this dais and everybody else in this room. So with that, we will have a roll call, Ms. Shanaz.
Planning Commissioners Astodian.
Here.
Landrigan.
Here.
Lee.
Here.
Manukian.
Here.
Very good. Ms. Stadler, report regarding the posting of the agenda.
The agenda for this meeting was posted on Wednesday, November 25th, 2015, on the bulletin board outside City Hall and on the city's website.
Very good. Then we will follow Commissioner Manukian in the Pledge of Allegiance.
I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. So do I have a motion for the approval of the minutes for November 18th?
I move approval of those minutes.
Very good. And we don't have any oral communications and no zoning appeals. Why don't we promptly move to, and there is no old business, why don't we probably move to Code Amendment Case Number PZC 1527218. I believe, Ms. Stotler, you're the one that is handling this.
Yes. This is a proposed amendments to Title 9 and 30 of the Glendale Municipal Code 1995 relating to medical marijuana dispensaries, marijuana cultivation, marijuana processing, and delivery or distribution of marijuana or medical cannabis products. This proposed amendment would add definitions relating to marijuana to Title 30, and so that's why it's before you. That's our Glendale Zoning Code, Section 30.10.070 zoning districts. Right now there's a prohibition against medical marijuana dispensaries. And what this amendment would do is it would expand that definition to include marijuana dispensaries, marijuana cultivation, marijuana processing and delivery or distribution of marijuana or medical cannabis products as prohibited uses. And it would be prohibited not only in all zones in the city, but that would also include specific plan areas as well. The reason this came about is on October 9th, 2015, Governor Brown signed the Medical Marijuana Regulation and Safety Act into law, and that becomes effective January 1st, 2016. That Medical Marijuana Regulation and Safety Act is comprised of three California bills, AB 243, AB 268 or 266, and SB 643. As part of those bills, if the city is given an opportunity to specifically prohibit those activities in the city, or conversely, if we don't want to prohibit them, we have an opportunity to allow for conditional use permits. And if we do allow for conditional use permits, then the city will also, or the state rather, will have a dual licensing authority as well with the city. The last time the state adopted medical marijuana dispensaries as a use that could occur, the city banned those uses and said, no, we wanted to retain local control. And on August 9th, 2011, the City of Council did pass Ordinance 5745 that banned the establishment and operation of medical marijuana dispensaries and other similar uses. In this case, we want to expand that prohibition to include all these new definitions and new types of uses that are being recognized by state law. So in front of you, you have an ordinance, and it was just recently amended tonight. You actually have a revision. And what that ordinance does is it amends Section 3010.070 zoning, as I read, but then it also provides definitions for those uses in Title 9, Chapter or Section 9.10.010 definitions, and you'll see definitions are being added for delivery, distribution, marijuana or cannabis, marijuana cultivation, marijuana processing, medical cannabis product or cannabis product, medical marijuana dispensary or marijuana dispensary. So all of those definitions are being either added or amended. And then we're also including in 910.020 additional prohibited activities. So we actually have consistency then between Title IX and Title 30 on the prohibited uses, Title IX being where you'll find those uses defined. And because of the state law taking in effect on January 1st of 2016, the city is under a tight timeline to actually have these prohibitions in effect and not only adopted but effective prior to March 1st, 2016. And so that's why we're bringing it before you tonight. We know it's quick turnaround, but we wanted to ask that you make a recommendation regarding this ordinance to City Council tonight. And then we would be able to bring this to the City Council for their consideration in January. So we would be able to meet the state deadline. So if you have any questions, I'm here to answer them. We also have our legal team that's been working on it. And we have our general counsel for our police chief and general counsel for the police department. They are absolutely concerned about this law, and just as they were the previous one that was passed, and they're here to answer any questions you may have regarding this.
So any questions for staff?
Yes, I have a question. I'm referring to Section 2, 9.10.010 definitions, paragraph F. Medical cannabis product, or cannabis product means a product containing cannabis, including but not limited to concentrates and extractions intended to be sold for use by medical cannabis patients in California pursuant to Compassionate Use Act of 1996. So there are individuals who take pills which contain certain portions that ultimately of marijuana, which ultimately is therapeutic to them. Is the sale of those otherwise legal pills in the city of Glendale by pharmacies illegal, or their provision?
When do you want to address it?
Let Carmen answer this one. My understanding is as long as they have a prescription, it's fine. I will let Carmen.
Good evening, Commissioners. My name is Carmen Marino, and I'm General Counsel for the Police Department. And maybe I can answer that question. Your question is whether the sale of medical marijuana would be prohibited in the city of Glendale.
Not medical marijuana. Medical marijuana, I mean, no.
Cannabis products?
There are pills that they have THC extract in them, and people can take them. They have prescription for them for multiple sclerosis or a number of other maladies.
My understanding is that a prescription is not authorized. What a physician can do is provide a recommendation. So it's not a prescription. That's my understanding. And I can inquire further with our narcotics lieutenant, who probably could answer that question, or the deputy chief. But as far as what the drug contains, I'm not quite certain, but I know that a physician cannot prescribe cannabis products because cannabis or marijuana is a Schedule I drug under federal law, and it's a controlled substance. So.
Carl Pavlidis, Deputy Police Chief. If it's an actual prescription, because there have been for a long time various drugs which do contain some of that extract, and you obtain it from a normal pharmacy, then it is approved by the FDA and the DEA, and so that would be fine. This deals with medical marijuana and the recommendations and those issues, not the items that you would get from a pharmacy.
Okay.
And any other questions for staff? I have a technical question. Perhaps this should go to the city attorney. Since there was an amendment, or the late amendments, and these have not been online, it's not been publicly available, and how do we go about that? Just and tell me if we should read it in the record.
Yes, I think that's absolutely appropriate. On Monday, a case was published out of the Fifth Circuit. It was the Dinah Kirby versus County of Fresno. It had to do with whether or not the County of Fresno could ban marijuana dispensaries cultivation and storage in its zoning districts, and the court upheld that ban. But another issue arose, and that was whether or not the individual there who apparently was a qualified patient under the Compassionate Use Act and the medical marijuana program could be arrested and it could be cited as a misdemeanor and arrested and criminally prosecuted. And that decision, the court discussed preemption and whether or not it was the Compassionate Use Act and the medical marijuana program talk about the decriminalization of certain activities. And in this particular instance, the court found that the city was preempted from prosecuting her under their municipal code as a criminal offense, as a misdemeanor. And so what we have done with our ordinance is make it very clear that if and to the extent that it is a criminal matter, it would be only prosecuted as a nuisance abatement as opposed to a violation of Title IX or Title 30 as a misdemeanor. So we had to make a distinction. So the language that you see there, I will read into the record just to make that clear. So if you look at 9.10020, which is prohibited activities, Section B, what was delivered to you read this way. Marijuana cultivation, marijuana processing, and delivery or distribution of marijuana or medical cannabis products are prohibited activities in the city, except where the city is preempted by state or federal law from enacting a prohibition on any such activity. What we added is this, or is preempted by federal or state law from enforcing any of these prohibitions. So it recognizes the state preemption concerning enforcement. That is with respect to the prohibited activity under Title IX. We repeated that language as well in Title 30, which would be the zoning violation, which is a misdemeanor under our code. And that was what the Kirby case found to be preempted by state law. And so I will read that change into the record as well, which was added to the end of, let me get to the correct section. It is in Section 3, which was amending Section 30.10.040. And then we would go to N, which is medical marijuana dispensary, marijuana cultivation, marijuana processing, and delivery or distribution of marijuana or medical cannabis products as prohibited uses. That's the title of that section. And it reads as follows. Notwithstanding any other provision of this code, a medical marijuana dispensary, marijuana cultivation, marijuana processing, and delivery or distribution of marijuana or medical cannabis products, as these terms are defined in Section 9.10010, are prohibited in all zones, including in all specific plans areas. And then what we added was, comma, except where the city is preempted by federal or state law from enacting a prohibition of any such prohibited uses, or is preempted by federal or state law from enforcing any of these prohibitions. So again, in recognition of the preemption of criminal enforcement. We have other means of enforcement, and that would be through nuisance abatement, were such activities or uses to persist beyond notice of their violation of our code.
So prior to this latest case, was a misdemeanor being prosecuted. Now it is a nuisance. Is that what it comes down to?
Well, we weren't under our code. Technically, a violation of the zoning code would be a misdemeanor, as well as under Title IX. So this is to make it clear, and the Kirby court was clear, and it's a published opinion concerning that distinction.
Very good. Okay, thank you. Any other questions? Can we have a motion?
I move that the Planning Commission recommends that the City Council adopt the proposed ordinance to amend the general municipal code sections discussed in the staff report regarding zoning code amendment case number PZC 1527218 dated December 2nd, 2015, relating to the prohibition of medical marijuana dispensaries, cultivation, processing, and delivery or distribution of marijuana and cannabis products.
With the amendments that were read in the record.
With the, per the amendments read into the record.
Second. May we have a roll call?
Planning Commissioners Landrigan,
Aye.
Lee,
Aye.
Manukian,
Aye.
Chairperson Astorian.
Yes. All right. Next case in front of us is item number 2, which deals with the code amendment case number PZC 1526368 and PZC 1527173, Glendale Municipal Code Amendment, Title 5 and 30, Downtown Specific Plan Amendment. And I believe it's Mr. Bakdigian that is going to be handling this.
Yes, I'm hiding over here. Mr. Chair and Planning Commissioners, this code amendment relates to massage uses and how they are permitted, and this is primarily coming to us in response to recent state legislation. And let me explain it a little bit. Prior to 2009, massage establishments were permitted by conditional use permit. In 2009, the state mandated that massage establishments be permitted the same way as other personal service or professional office uses, which was by right. So we amended the code at the time to permit massage establishments by right. And this is statewide also. Because this led to various regulatory and other enforcement issues, the state passed new legislation which allowed cities again, or municipalities, to regulate massage establishments differently from other personal service uses. So to respond to this, the city passed a moratorium in January of 2015 so that new permits wouldn't be issued, and in the meantime we would study and come up massage uses and come up with a set of regulations and recommendation. So we are here tonight to review a proposed ordinance, and the Planning Commission will make a recommendation on those proposed ordinances to the City Council. Having said this, let me go over the ordinance very briefly as to what is included. There are two draft ordinances. The first one addresses Title 30 requirements, which is the zoning code. The second one modifies standards in the downtown specific plan. And the third one is Title 5 and is included for reference purposes. So the changes to Title 30 and the downtown specific plan primarily relate to changing massage establishment uses from a permitted use to requiring a conditional use permit. That's one. The second part of this ordinance, which is on page 30 and 31 of this ordinance, it adds a set of standards to deal with non-conforming massage establishments. And the third part of this ordinance, which is on page 31, defines massage establishments, and it makes a reference to a detailed definition of massage establishments located in Title 5. And the second draft ordinance is, again, reinserts the conditional use permit requirement for massage establishments in the DSP zone. The third ordinance which is not under the purview of the Planning Commission but is included for reference purposes, is modifications to Title V. Now, Title V has detailed standards for massage establishments, and what we've added to it is standards that relate to the layout and other requirements that massage establishments have to comply with, all massage establishments. Primarily, this relates to having an opening or an open, transparent surface to provide visibility into the lobby area of the massage establishment. And the standards for this transparent area are designated in Title V. It requires at least 10 square feet of glazed area that gives access, that makes the hallway of that makes the lobby of the massage establishment visible from an exterior common location, like a sidewalk or street or a common or a parking area or a common hallway. So these are primarily the standards that have been placed in Title V but referenced in Title 30. Since we distributed the report and the draft ordinances, we made some changes to Title 30 on page 30 and 31. The handout in front of you is a two-page handout that contains highlighted areas in yellow. Those are the paragraphs where we made the changes, and let me explain what they relate to. Non-conforming massage establishments have to comply with the new standards being proposed if this ordinance passes the way we drafted it. There's a certain time frame for massage establishments, non-conforming massage establishments, to apply for a conditional use permit. Another time frame to obtain a conditional use permit and to comply with all the requirements of the conditional use permit and any other standards in Title 30 and Title 5 within a certain period of time. The changes clarify that to comply with standards that do not require a building permit, the time frame to comply with those is very short. And those standards can be, for instance, like removing curtains to provide that visibility to the lobby area, or removing furniture that blocks the required glazed area. And the changes also clarify that requirements that are subject to a building permit, the time frame to comply with those is longer than those for which a building permit is not required. So those are primarily the changes, and they've been highlighted in yellow on the handout. So we would, with the concurrence of the Planning Commission, we would like to replace what was distributed with what was handed out tonight. Having said this, I would like to conclude my presentation unless there are questions from the Planning Commissioners.
Any questions for Mr. Bagdikian?
So simply put, then, by this 2018, that we're trying to bring all establishments to the, that meets the code. So there is no longer grandfather clause that is allowed, but that every establishment needs to comply.
Yes. That's March 1, 2018.
So, excuse me, this is for only massage establishments, not establishments that also offer massage, just an establishment that is considered a massage parlor, etc.
Yes, because technically there are, for instance, medical office uses that provide massage services, but they are permitted under that medical office use.
Okay.
So those are not subject to these regulations.
Thank you.
Any other questions for Mr. Bagdikian? Just the same nature of question.
Yes.
When these amendments, this highlighted, yellow highlighted amendments were done, were these online or were these published before? Or these are late?
They're not online. These were done this morning. We provided them to the Planning Commission. If the Planning Commission concurs, we'll insert them in the council's review.
But I, just to be copacetic about this stuff, can we read that into?
No problem.
And then we will incorporate them.
So I'll read the provision as proposed to be amended, and this will be section 30.60.030, capital M3. So the revised provision would read, on or before March 31, 2016, a legal non-conforming massage establishment must fully comply with all applicable requirements in Chapter 5.64 of this code, for which a building permit is not required. Provision M4 would read, if a legal non-conforming massage establishment has been granted a conditional use permit, any improvement or alteration to the building or structure of that massage establishment for which a building permit is required, and which is required by either the conditional use permit, Title 30 of this code, Chapter 5.64 of this code, or the Glendale Building and Safety Code, must be completed with a final inspection on or before the 180th consecutive calendar day after the date on which the conditional use permit was granted. Any one or more extensions to complete the work contemplated under the building permit that are granted by the building official shall extend this deadline accordingly for as long as the permit remains current and valid. Then provision 5, M5 small b would read, the massage establishment fails to obtain a conditional use permit on or before March 1, 2018. And this provision relates to what happens to a massage establishment if it fails to obtain a conditional use permit. It means it will have to be shut down or cease to operate. And then there's provision M6, and that provision would read, a legal non-conforming massage establishment must cease all business operations on or before March 1, 2018. All signs, advertising, and displays relating to that business must be removed completely on or before March 31, 2018. And this is a listing of all the changes that we're proposing tonight.
Thank you, Mr. Bagdagin. If there are no questions, can we have a motion on this item?
Give me a second.
Sure.
Mr. Chairman, I would like to move that the Planning Commission recommend that the City Council adopt the proposed ordinances to amend the Glendale Municipal Code related to zoning code amendment cases number PZC 1526386 and number PZC 1527137.
There is a second.
Second.
Discussion? None.
Question.
Ms. Shanaz, we will be looking for a roll call.
Planning Commissioners Landrigan,
Aye.
Lee,
Aye.
Manukian,
Aye.
Chairperson Astorian.
Yes. Thank you. And so item number 8 is Community Development Department updates. Are there any?
We have no updates.
No updates. Any comments from fellow commissioners? Seeing none, hearing none, we'll call for an adjournment.
So moved.
Thank you.